Good morning, everyone. It is July 22nd, 2026, and I cannot believe we're almost halfway through the year. And this morning, we have a topic that everybody always comes up, and people obviously know me for workers' comp. But today, we're not going to have a workers' comp rep, a workers' comp risk manager. We're actually going to have a workers' comp attorney, defense attorney. So, for all the employers, HR, risk managers, anybody that has or deals with workers' comp in California, today is a day that you want to ask Mr. Hector the questions. And I'm going to go ahead and let Mr. Hector introduce himself to the audience. So, Hector, tell us who you are and what you do.
Good morning, everyone. Thanks for joining. So I have a boutique firm in Long Beach. We do primarily defense workers' comp, variety of issues, including serious and willful and 132A type claims. We have a wide range of employers that we represent throughout the years, school districts, supermarkets, hospitals, you name it. I have a huge inventory. So we face all issues in the spectrum that comes up in our wonderful workers' comp world. Not very friendly to the employers, but that's what we're here for, to minimize damages and exposure.
Thank you. And, workers' comp, I always tell everybody, it's its own different world here in California, just as like it is in New York. So you have to play with whatever the rules are. I know it's very favored on the employee side, but that's because of the way the state is set up. So I always tell all of my employers, okay, there are regulations, there are rules, and ultimately what goes on is, as everybody knows, is that these claims go on to your experience modification, and as you know, the experience modification is what impacts your premiums. And just like every employer, they all want to make sure and know that they are doing the best they can to make sure they keep their costs below, and also know what to do when it comes to managing a workers' comp case correctly. Now, just like there is a process to workers' comp, there are also a lot of errors that employers themselves do that make the claim drag out, make the claim not as efficient as it should be. And that is exactly what today's call is about. Today's call is about what mistakes employers do that cause a workers' comp claim to either be delayed, not be addressed correctly. And I'm going to start off actually with two questions that we have from Instagram. The question here is from Landscaper5204. He has a question. His question is, if I have a workers' comp and I know that the guy is working somewhere else, what can I do to help me fight this claim?
All right, so that's a very typical scenario.
I know.
Much more typical in the landscaping business. And so it's great intel when you have that and you have that information that whomever it is working elsewhere. Two things happen. If the case is litigated and is already tendered to your policy, there's an open claim, that is really good information to give to your point of contact, your claims examiner, whomever it is that you deal with, to give actionable information so that they can schedule an investigator out and to confirm all the information. Because two things could be happening at the same time. If the individual is working elsewhere but not reporting that he's working elsewhere, he may be committing insurance fraud if he's collecting benefits. And that information is extremely valuable to the doctors, because if he's working elsewhere and he may be violating restrictions, he may be aggravating the current condition. And so the result of that is that if that can be proven, you can join the other company to sharing the cost of what's been going in your claim.
That's a really good point that you bring up, Hector. And many people don't know that. And that's why it's really hard to connect the dots and also prove, because, in California, It's so hard to prove fraud because fraud is not what people think. You know, like in many employers' eyes, what this question shows and what everybody else has experienced, to them, it's fraud because it's like, oh, how can this person be working somewhere else if I know they are doing exactly the same thing and so forth? But that's not the actual fraud behind it when you look at the definition.
Right.
So you bring up a really great point in gathering the information and knowing where this person is working, which also makes it a little more difficult, right? Because a lot of the times people either are working under the table or um, they might be working they they might be doing something that is not necessarily what the restrictions are. And that's what I always tell people. Like, look,
Right.
if the restrictions are not what this person is, claiming to be injured, it's going to be a hard case to fight. But if this person is completely disabled, unable to work, then yes, we do have a case here.
Yeah, and the other thing that could happen also is it could be using a different name. And
Mhm.
so it's very important if you have actionable information that you know exactly where he's working, and so that an investigator can go out, ID the person, take good video of the person, a good visual, because if you're going to subpoena records of that company, you might not find them that way because it could be using a different name. So you need the visual. So the first thing is that provide really good intel, as detailed as possible, to the point of contact, examiner or whomever, once the claim is open, obviously, right?
Yes. Then we have the second question over here from Redlands Plumber. His question is, if I paid this guy cash, how do I prove that? How do I prove, I guess, workers' comp statements to the workers' comp case?
Yeah. So if you pay cash, it doesn't matter how you pay. He's an employee, right? And that's the one thing that an injured worker needs to have a valid claim to prove employment relationship. So paying the cash has some difficulties in other type of issues, such as wage and hour type issues that they may be uh, also coming after those type of claims, and so that's the danger in paying cash. If you have some sort of record receipt of payment given and payment received and date, and keeping a good ledger of that, that's one way that will help you. Just keeping good records of the form of payment. Not the most um, advisable way of paying employees, because there are other problems associated with that, tax and things like that.
Yeah, definitely. Cash is a big issue. I don't know why people still continue to do it. There's so many rules and regulations, and there's a lot of things that, warn you about not using that. But we do have a question here from Maria Crump. It says, I got a workers' comp case with surveillance and workers' comp did nothing.
Yeah. Well, okay. So it's very, like Rocio mentioned earlier, is very, very difficult to prove things such as fraud. And it's very aggravating also. You need a lot. You need, in addition to the surveillance, you need a lot more. So, but the quality of the surveillance is really important. You can have tons of surveillance, but if you don't have the proper ID, in other words, you may have the person doing stuff, but it only shows one side of the person, or the back of the person. It is that person, but it doesn't show the face as clear as needed for a judge to act on. No one is going to bring up the case or even refer it to SIU or to the district attorney. So the quality of the surveillance is extremely important. Now, the question is a little vague when you say workers' comp has done nothing. Are you referring to the case going to the WCAB, to a judge, and to prove there was no injury, or what exactly are you referring as to workers' comp? Because the WCAP does not necessarily deal with fraud. That's an issue that goes to the district attorney.
That's a good point, Hector. And when it comes to surveillance, I hear that a lot from the insureds. I hear this all the time. Hey, I got surveillance. We got someone from the insurance carrier to go out there, and they saw this guy was working, but they still paid him out. And or sometimes surveillance is wasted, and unfortunately they're not able to get anything.
Well, the other thing with surveillance is it's an art, okay? Because you need more than one day. Let me just give you an example. You have an injured worker who is out on temporary disability, but then he's out playing basketball, or he's out, taking the trash out. Then you go to the doctor and say, hey, look what he's doing, right? The answer that you're going to get is, well, on that day, he was having a good day. Or he just had his medication and he did this for a little bit and it's fine. So you need a sequence. You need to have surveillance. What I recommend my clients to do is to do surveillance the day before an appointment, the day of the appointment, and the day after a medical appointment. So that when they go to a doctor and they make all these complaints to a doctor, then you can challenge that, right? You can challenge that credibility by saying, well, look what he did yesterday. And then coincidentally, when he comes to you, he complains. And then the day after, he's fine. So if you have that pattern and you're able to that sequence of surveillance, that's a much more effective use of surveillance, because surveillance is very expensive. So you got to schedule it properly.
Yeah, no, she commented saying they still paid him.
Yeah, and so when you, I'm assuming when you say they still paid him, it could be that they still settled the case. I'm just gonna take that assumption, and so there are different answers to that. One of them could be that when you look at the case as a whole, right? Because these cases are expensive, and so someone is making that determination, a business decision of what is the business sense of keeping the case open to continue challenging and taking it to trial, as opposed to cutting it off earlier to manage or contain costs. Because mind you, going to trial is not a guarantee, right? You can have a really good case, go to trial and still lose for many other reasons unrelated to the surveillance. And so you have someone in the making that determination. It's going to take us another 6 months before we get to a trial, and by then we're going to be incurring this much cost. Well, let's just close it now, and yeah, it's too bad. We do have good evidence, but because there are no guarantees, then they make that business decision of, okay, let's settle.
Yeah, and that's a really great point, because I always have this frank conversation with all of my clients, all the prospects as well, is that, look, yes, I know this person's lying and we could fight tooth and nail, but ultimately it's going to cost you in the long run. Because instead of, settling out this claim early on, we are going to have this claim open on our loss runs in XMOD. And instead of maybe closing this claim out for 10,000, 12,000, now it's going to be opened up to 50,000 for the next 2 years. And that is just for that specific claim. If we have other claims that are going to go onto your experience mod, and we're going to do the same thing for every claim, it's going to make no sense for you, because again, it's an uphill battle.
Right. Absolutely. Yeah. And so, and it's because the way the system is set up, that it takes so long to get hearings, to get a final report from doctors, while you are building up the evidence to challenge the case, you continue to incur all those costs. And so that's why the determination has to be made at some point. Do we continue to challenge all this and hope at the end we win? But there's a risk, because it's not 100% guaranteed. We close it out.
Yep. Have another question here from Roberto. If they had no accidents, how do you prove that?
Okay, if they had no accidents, how do you prove that? Let me try to interpret the question. So someone alleges that there was an accident, but there was no accident. That's how I'm going to interpret it. Is that how you take it, Rocio?
Yeah,
So
that's what I'm interpreting.
that's the scenario of a typical scenario of someone who say, "Hey, I got hurt at work, but nothing happened." Employers where the premises have surveillance cameras, and you can have all that video of showing the individual working at a specific workstation, and there was nothing unusual every day. It was the same. That alone is evidence of nothing happened, right? Because you can have surveillance, those video cameras, that footage for two reasons. One, to prove that something did happen, but not in the way that is being alleged, or the absence of anything unusual happen also serves to prove nothing happened. Really difficult task to do, but you can do that. You can prove that with, if you have a video, but also with corroborating evidence of nothing being there. For example, someone say, I injured my back, right? And then through the medical workup, the MRI shows nothing, there are no positive findings, or the x-rays, it's all just subjective. Credibility of the individual, statements by other witnesses that they never saw anything. That's how you prove nothing happened. Let's see. It's a CT claim after termination. Yeah. Those are typical, okay? every time there's termination, there's a CT claim, and there's a specific reason for that, okay? CT is a very, very complex type of a claim, okay? The easy one is a specific injury, right? Because it's factual. It happened or it didn't happen, and you prove the facts with evidence, right? This CT concept, cumulative trauma concept, is extremely complex because the person worked there for however length of time, then gets terminated. Now they're upset, right? That's called a retaliatory type claim because, hey, they terminated me. I got to do something against them. And then an attorney will tell them, well, let's see how long you worked there, what you do with your hands. Oh, you know what? Your hands did hurt. That's it. That's how you create a CT claim. Really easy. And so you have the post-term defense. There is a defense, which is a post-term defense, where you put up evidence that prior to termination, there was never any reporting of any claims. The guy was, or the individual was never out, did not have any medical treatment. There are no medical records, right? So that is one way to prove a post-term defense for a CT claim. The problem with that is that because we live in this environment, a very friendly environment for the employees, the code itself is written that specifically says all doubts are resolved in favor of the injured worker. That doubt is that the person say, well, yeah, I just never told anybody, but I did have these complaints, and it's because of what I did. That's all they need to say. They don't need to say anything else. They give that to a doctor, and the doctor has to accept that as true. And then the doctor will build a CT claim for them. So it's tough. It's really tough to do that.
And then Hector, if you don't mind, can you give us the definition of cumulative trauma claim? Just because we all know it's a popular claim, and unfortunately, this is what all employers are seeing across,
Right. So cumulative trauma, which is there, we use a lot of acronyms in workers' comp. CT, or cumulative trauma, is a type of trauma that develops throughout time. Okay, there's no specific event that happened. That's a specific date of injury. Something you can identify at a point in time where something happened. Well, the cumulative trauma, it happens, it's a symptom that develops through time because of someone's nature of duties, right? And so the law requires that whenever there is an injury, that there is notice meaning that the employer should know something happened, right? But in the cumulative trauma, because at the type of injury it is something that develops through time, then the case law has developed in such a way that it says, well, this person had something, but they did not know that it was because of work. And it's not until someone tells them that or connects the job duties to whatever symptom develop is when they know that they have a cumulative trauma. So that's what it is. It's a symptom that develops, back soreness throughout the time, develops, continue months in and months out, but the person never told the employer anything about it. And then the excuse is, well, I didn't know it was because of work. Until the doctor told me, oh, is that the work you do? That's why you're feeling this way. And that creates a cumulative trauma.
Yeah. And as many people know, stress is also added on there. I've seen all types of cumulative trauma. But I think where employers get really frustrated is when it's a CT claim that maybe it's, for the back, and then they get hit with a second CT claim, or the CT claim then gets added because, they're working with people that obviously are trying to get most out of it. And then next thing you know, we see a request for dental, stress, stomach. I mean, those are the ones where you're just like, oh man, you're close to wrapping it up, but now they're contesting with a PQ&E on the stuff.
That's what's happened, and that developed after the law change. It's called SBA 63, which created this PQ&E system, panel qualified medical evaluators, where the person goes to the doctor for a back injury and then tells the doctor, by the way, my stomach hurts. And then now they bring internal in. And then, by the way, I'm losing my hair. And then you add another claim. By the way, my teeth are, I'm feeling things at night. Boom, you got dental. And the problem with that is that the initial panel doctor that saw this person, because the specialty was orthopedic, then he's going to say, well, that's outside my expertise. You need to go to an internist. And then for the dental, the internist is going to say, well, that's outside my expertise. You need to go to a dentist. And that's how it snowballs. Before you know it, you have 3 different specialties in one case where there should have only been one orthopedic doctor. Those are called compensable consequences and adds value to the cases.
And is there a way that employers can navigate that, or?
Very difficult because since it becomes a medical determination, the moment that when the person is going to go to his first, what's called med-legal evaluation with a PQ&E, with a panel qualified medical evaluator, what's going to happen is his attorney or her attorney is going to call them a couple of days before and say, be sure when you're there at the examination table, you tell the doctor not only about the back pain, but also tell the doctor about everything else, right? Everything in the kitchen sink. And that's it. The employer cannot, there's no control. The employer has no control of that process at all. The moment that the claim opens and the person is referred to a PQ&E, that's it. Now it's all up to the legal system, the workers' comp system, the attorneys, the discovery process, and the medical reports.
Yeah, it's isn't there? I believe I want to say I did recently see there's a reformation or some type of bill that I think California is trying to work on for CT claims, or the statutory limits.
Yeah, well, there's a lot that is being talked, not only in CT claims, but other aspects that have been going on because just about every 5 years there's a new development in the law, right?
Mm-hmm.
And so this the CT claim does require some restraining, but I don't see it happening because anytime soon, because throughout the years, so much case law has developed already just on CT claims that I don't see relief for on the defense side just yet on the CT claims. We did have, a lot of relief on the side claims, on the stress claims, with a big change through SBA 63, because before that, the stress claims were just going out of control. And thank God the legislation came in, and now we have new regulation in place to control that substantially. The change was very positive for defendants. But the CT, it's an animal that we're going to be living with for quite a while.
Oh man. And yeah, and that's the frustrating part because if you look at other states, they don't, I mean, besides New York, they don't really face these challenges.
Right. It's California. I mean, I have clients, paper mills from back east that have facilities here in, City of Industry or whatever, and it's very tough for me to explain to them, that a case is worth so much money because we're in California. It's the cost of doing business in California, but I don't have good news for them because it is easier. Other states are not as litigious as we are.
Yeah.
All right.
We have a question from Chell M. How can employers protect themselves against CT?
Okay, so employers, again, CT very difficult because it's so subjective. But employers can protect themselves and prevent to a certain extent not only CTs but many other types of injuries by being very vigilant, by providing good safety measures and good training in to perform whatever job it is that someone is doing, right? By making sure that the person is not violating safety rules, right? Providing ergonomic stations. If someone is at a desk all day, that's definitely a prime candidate for a CT of hands or back. Well, an ergonomic station is going to help, but it's costly, right? So work alongside risk management to come up with the strategies, right? That supermarkets, someone is at the warehouse, instead of breaking a pallet, only one person, have 2 or 3 persons breaking a pallet, right? And so that repetitive movement is reduced. It's very, very hard to come up with every scenario because the industries and it's so wide, the range, that when I'm asked to go to a company to give ideas and strategies how to prevent CTs or other injuries, I go and conduct an inspection and I say, okay, you got to do this, you got to make these changes here, improve the lighting here, improve the workstation here. But that's targeted towards that particular company. It's very hard to come up with ideas for everyone because it's very specific. So doing that, have someone to go and visit your work premises, right? And someone with the knowledge of what can cause a cumulative trauma and reduce or come up with the strategies to do that.
Yeah. And then, since we do have a lot of contractors on all 3 channels, it's really hard for them, right? Because if you're a plumber or you're a concrete person and all they do is lay out, and because everyone's a very specific and there's only so much work that they could really offer because they're not a general contractor where they could switch and trade people, it's very like, yeah, these guys are digging holes, they're on the operating machine, machine operators. And it could get really difficult because, that person is hired specifically just to do that trade and work that specific job.
Exactly. Yeah. But the employers, they could do a lot. They could do a lot to take preventive measures. It takes a lot of observing how someone is doing something and taking corrective action immediately. All right. And, reduce the amount of time someone is doing the same type of activity. If that's possible, but that creates manpower. It's going to likely, require a company to hire more people to do the same job. Things that are costly.
Yep. And that's why, a lot of construction companies have adapted the stretch and flex, stretch and flex exercises right before they start, in the middle, break time. And now they're very proactive, making sure that they have a safety person walking around and that people are following protocol on that, especially when it comes to construction. Construction really takes safety really serious because they have to, but also because they have to, adapt with that. Because you mentioned in the beginning how you guys deal with serious and willful claims, and if anyone were to get hit with OSHA violation, they are on the hook because, I've come across many contractors where they've had several eye injuries and now they're on their third fine with OSHA, and, they just have to face the consequences because obviously if it's a repeated mistake and they're not taking the right corrective measures, and it's not necessarily that they might be unsafe. It might just be because they don't want to be, sometimes they don't want to come off like the safety police, or that person has worked for them so long that, they don't want them to feel that they have to, take all these extra steps to be safe. But at the end of the day, you do have to take those extra steps because everybody has a home to go to. We all want our men and women to go back to work, go back to their families, and being able to, to function because our employees are the most valuable thing that we have.
Yeah, no, absolutely. Now, one more thing that comes to mind is on the point of being vigilant. When employees tell a supervisor, I'm a bit sore today, or whatever complaint, however light it might be, don't ignore it. Do something about it, because that could be something that was mentioned in passing one day. It could come back to haunt you 6 months to a year later. And that's where the CT starts. And now you had some sort of notice. And so it goes back in time. So it's providing good training to your supervisors, the ones that are there with the employees. And when they hear comments from an employee, there might be something to it. Someone could legitimately say that. An employee could say, hey, I'm a bit sore today. And that's it. That's the end of it. Well, now it's time to start watching that person. Okay. And do something about it. Because not doing, you don't have a crystal ball. You don't know what's going to happen in 6 months to a year. And that could be significant later on.
Yeah. And then what advice do you give to employers because that does happen, a lot of the time someone might come up, hey, I'm feeling my back hurts a little bit. But sometimes employees don't want to ask directly because they don't want to come off like, hey, like I'm complaining, or I don't want you to think I want to open a workers' comp. I just want to let you know that I am in pain. Do you suggest that they go see a doctor right away? Because I think sometimes some employers, they want to take care of it on their own, thinking, it's the right thing to do. But I always tell everybody, no, like that's why you have workers' comp. You just send them over to workers' comp, have a report, because like you mentioned, this might come back and bite you in the butt. And next thing you know, we have a case.
Yeah, it's tough because damn if you do, damn if you don't. So if you hear it, right, you have to use your best judgment and kind of identify what it is that you're being told and look at the person who are you dealing with. Obviously, best practice, the moment that I hear any complaint whatsoever, will be, all right, go to a doctor, and once the doctor tells you you're okay to be back here working doing the same thing, come back. That should be the automatic answer. But then, there is that fear always of, oh, now I'm going to open myself a workers' comp claim for this individual, right? So it takes that, that type of gut feeling of how you're going to handle that. If you're afraid that you might be opening a unnecessarily a workers' comp claim, but then if you don't, that can come back to haunt you later. So it's making that determination how we're going to handle those type of complaints, right? Now, there are two types of claims, right? Because by law, when there's an injury, you're supposed to give the employee the DWC-1 form immediately, right? Except there's one exception, a first aid type injury. So it's not necessarily that you're going to report everything, because you may be facing a first aid type injury where no doubt DWC-1 is required. But we're not doctors. We don't know what's going on with the person. So that is where the person tells you today, hey, you know what, I'm a little bit sore today. Typical answer of some employers are, go take a 15-minute break. That's it. Another answer that I see later on in time when I'm developing cases, just take an Advil, you'll be fine. And I'll give you the Advil myself. And then I see the case later, 6 months later. Something else would be, just go home and come back tomorrow. There are problems with all those three answers, and those are the most typical answers, because we're not doctors. We don't know what's going on with this person, what's causing that. So the answer should be, go see a doctor, let a doctor tell you what you have. The doctor says you can't come back to work yet, you can't come back to work. Because coming back to work, or take the Advil and continue working, or take a 15-minute break and continue working, or go home and come back tomorrow, that creates the onset of the CT.
Yeah. And you said it perfectly. We're not doctors. We're not the first one to call, to determine what is wrong with anybody. And that's why it's important to have, your first line of defense. Either, I know a lot of contractors and companies use a nurse triage where they might call and the person speaks with someone that is trained, and they tell them their symptoms, and then they say, okay, this is what I recommend, or no, we're going to send you right over to the clinic. There's also other first aid responders, but that's obviously when, you see someone with a laceration, an eye, they could go out there and treat the employee, but they still talk to them. So we, to make sure to have it, recorded, stated, documented. And we just mentioned it, the reason why all of this happens, it's because we as employers don't document things. And we don't train our supervisors as well, because we might know exactly what the laws are and what the rules are. But if our supervisors, which are the first line of defense, they're not communicating well with the employee, then, there's going to be tension, there's going to be friction. And ultimately, it all comes down to the company, because you are accountable to making sure that everybody is, trained on this.
Yeah, this is something that I do a lot of training on. Employers that have a lot of problems with a lot of claims. Why are we having so many claims? Why are we having so many claims? And I go and try to identify the reasons. And I've done training with a lot of employers where I see that the first thing to do is to train the supervisors and what I typically do is I tell them, hey, you need to be sensitive to these individuals, right? And communicate with them, follow up with them. How are you feeling? How are you doing today? Are you better? Doing that type of following up with employees resulted in, and I've seen that in the past when I actually, with some of my clients, resulted in reduction of claims, because the increase of claims in this particular company that I was working with was the fact that the supervisors will get really upset when someone was injured. And they were not upset at the individual, they were upset at the fact that now there are 1 man down or 2 men down, and then now they had to do more work, or they had to, look for, the stress themselves to having to figure out how they're going to fill the gap for, the person they don't have any longer, right? So there is that resentment, and that component makes a difference, right? How you handle that, and the person that will first get that information will be typically the supervisors. So, showing apathy or empathy makes a difference. How you handle it.
Yeah, 100%. It all comes down to communication and, empathy and connection with, just showing someone that you care for them, because that's why, nurse triage is so successful as well, because at that moment the person feels that they're being listened to, they're being addressed, versus, okay, just let me know how you feel by tomorrow or at the end of the day, or they just don't, they disregard it. But we're coming out close over here to the 11:45 mark. Hector, is there anything else you would like the audience to know about you? And then where can they contact you, for your services?
So I think I put my email on I don't know if you see it on the screen. And I do a lot of consulting with employers or a lot of different folks in the business as far as claims that haven't even made it to the litigation world yet. They're still in the infant stages. That's one of the services that I provide, and I'm always happy to do that. Like I said, I have a huge inventory of or a range of employers that I've represented throughout the years, so I know a lot of issues of many different scenarios, because not every industry is the same. Each industry has their particular way of operating, and so you have to know that. You have to know how construction works, how a hospital works, how a school works. I even represent the county with police officers and firefighters. Every injury is different. You may have a back injury, but how it happened is completely different than how it happened to someone doing janitorial services, or someone working at a supermarket. So I recognize all those issues because I've dealt with them throughout the years. And also on the employer side, the claims of the termination claims, the 132A claim, which is more of a discrimination type claim, that is not covered typically by your workers' comp policy. So I also do that type of representation for what's called a 132A claim or a serious and willful.
And then for those cases, the off question over here, because sometimes, and I would say a good majority of the time, people don't carry EPLI until they have to, and it's been unfortunate, right? Back when I used to manage claims, and I had to tell the person saying, hey, well, this is not covered. This will not. Sometimes it is thrown into the settlement, but if it's more, if there's more, evidence to it, then the workers' comp will say, no, you have to submit this over to your EPLI policy. And if they don't have that, then, poor employer, they're out in either paying for it or getting someone to defend them.
Yeah, they're typically not covered. So that's where I come in. But the beauty of those is that they can plead them. Just because they plead it doesn't mean there's a viable claim. So the the great thing is that typically, once the workers' comp claim is resolved by settlement, if that settlement is properly done, it should include the dismissal of a 132A or an S&W for about 95% of the cases. But if it's not, if that settlement is not properly done, then yeah, that's an additional claim that has not yet been resolved.
Oh man. Yeah. Everything you just said, you know, just headaches and things that you don't want to face, and that's why you have to follow, you know, proper protocol to make sure that you, if you are accused of that, to at least you're able to defend yourself and not, you know, add more fire to what has gone and what has happened. But Hector, you know, it's been a pleasure to have you on here. I'm going to make sure in the comments that your email is on there, along with your website, and you're also tagged on the event. So for all my audience listening, you could go ahead and follow him. This is also streaming live on YouTube, so I will make sure that the YouTube comments have his direct information. And you know, it's been a pleasure to have you here and talk more about TT claims. I know TT claims are just, you know, they're just frustrating. I just tell everybody, like, it's just, this is the nature of California. And it's because why? Because of the state. There's, you know, the state has its own way of creating things, and until the state changes and the state legislation does, then slowly it might, you know, trickle down here. But as far as things are looking at what it is, no, this is, you know, unfortunately, this is what California workers' comp system is.
Yes. Yeah. Well, pleasure. Thanks for the invite. And you know, I'll answer emails, questions, anything. Make myself available for that.
Sounds good. All right. Thank you, everybody. And we'll catch you guys on the next one. Bye.